Good morning. Can I welcome everyone to this, the 26th meeting of the Justice Committee in 2012. Can I ask everyone to switch off mobile phones and other electronic devices completely, as the interview of the broadcasting system, even when switched to silent. Apologies have been received from David McLetch and Alice McInnes, and I welcome back Gordon MacDonald for perhaps his last time so far as a substitute in the Justice Committee, or is it just simply he loves our company? Going on to item 1, decision on taking business in private. Can I ask the committee whether they'll agree to take item 5 in private? Agreed. Thank you very much. Item 2, Scottish Civil Justice Council Criminal Legal Assistance Bill. This is our final day of evidence on this bill. For the first panel, I welcome Dr. Cyrus Tata, Reader in Law at Strathclyde University. I thank you for your written submission, which we've all had. I remind members that this session will focus on part 2 of the bill. Questions from members, please. Have I moved too quickly? Rod, please.
Good morning. Could I perhaps just turn to your point 2, no refund even if you're acquitted? Are you able to perhaps talk more fully about international experience in respect to this principle of reimbursing an acquitted defendant?
Yes, thank you very much. And I should start with an apology that you've only recently just had the evidence. My excuse, if it is one, is that at the time when the call for evidence came, I was on paternity leave, so I've been playing catch-up, so I'm sorry I've only just had that. That is a very interesting and important question, and one which I haven't had time as yet to explore fully. But my understanding is it's not that common, and I would be interested for us to think about and to take advice on whether that point would be in compliance with the ECHR in terms of Article 6. But that may be something that you may wish to investigate further. But I can't give you chapter and verse on the international comparisons on that, other than to say that I'm not aware of too many nations that would that take up that practice of not refunding persons who are acquitted. I think a fairer way to go, if I might just elaborate a little bit further, would be to apply requirements to pay contributions towards the cost at the end of the case, when we know the outcome of the case, rather than before it. It seems to me to be fundamentally unjust to require payment in advance and then not to refund to that person if they are acquitted. I do suspect that it would come as a nasty shock not only to the person who had been through the harrowing process of being an accused person, to find that they won't even get the money back. Not only have they had to suffer the social stigma, the whole legal process, possibly being detained, personal collateral consequences such as family breakdown, loss of employment even, and then to find that you're not going to get any money back, having been acquitted, having been hauled through that process. I suspect most of the general public would find that quite difficult to understand as well.
If I was to say to you that in the relatively short time I've been a member of the Scottish Parliament, I've certainly not had a letter at all from any privately funded, at the present time, defendant who'd subsequently been acquitted who has complained about the system. Would that surprise you?
That probably wouldn't surprise me a great deal, mainly because there aren't that many private paying clients. There are a few, but most of them tend to be very wealthy. I see where you're coming from in terms of a comparison there with the private paying clients, but I'm a bit concerned that the bill seems to be motivated by a view that we should be concerned first and foremost about fairness to the private paying client, that if the private paying client doesn't get a refund when they're acquitted, then neither should the rest of us. That seems to me to be suggests rather odd priorities.
Okay, happy to.
Do you have supplementaries on Can I ask, you've asserted that there are it's extremely rare for privately paying individuals. Can you give us that as a percentage?
I don't have a percentage to hand, but I'm sure SLAB can give that to you, or I could provide that to you later.
I would like that, please, yes. I think it would be quite useful if we're discussing it, if you've asserted that. The second thing is, we have a not proven verdict in Scotland. Are you suggesting that this should be extended to not proven, a refund?
Absolutely, not proven is a verdict of acquittal.
So acquittal and not proven is...
Yeah. Without getting into the whole not proven verdict...
No, just for clarification,
debate. Yes, absolutely.
Graham, you are down anyway, you're next. And then you can go on to the next one. Yes, thanks.
You talk about the fairness of pay for the process in the event that you've been found not guilty or not proven. You've looked at the system, as you say in your evidence, for the last 20 years. And in those circumstances where someone is either found not guilty or not proven, would it be appropriate for a judge to make a decision on the circumstances of the case, whether or not there should be a reimbursement of costs? What I've got in mind there, devil's advocate, in the event that someone's conduct is such that they have placed themselves before the court, even although the court has decided whatever they were involved in did not amount to guilt of a crime, it would be unfair for the state to bear the burden of that process. Is that a fair thing to look at? Is that too complex?
I think it would be too complex, Mr. Pearson. I can see where you're coming from as devil's advocate on that. And of course, the tabloids are always full of the idea that even if someone's acquitted, they're really guilty. Well, it's in our system of justice, and any system of justice based on the rule of law, it's the court of law which determines whether or not someone is guilty or whether they are to be presumed innocent and therefore acquitted. I would think it would be a very dangerous situation in which then a judge was asked to say, look behind his or her own verdict, or indeed a jury's verdict, and say, well, you were acquitted, but really I think you were sort of guilty, so we'll make you pay something for that. And I'm rather doubtful about the legality of that, as I say, because of the rule of law considerations there.
I'm grateful for that.
Before you move on, I think I'll be back in here.
From what I understand of what Graham Pearson said, it sounded very much to me very similar to the practice in England, that the opportunity that a judge would have. So I'm a bit surprised by your answer, to be honest.
My understanding is that a refund is possible at the end of upon acquittal. I'm not aware, but it's something that I can look into, and you may wish to look into, that a Crown Court judge, for example, can look behind a jury's verdict and say, but on the basis of the evidence, even though the jury has acquitted you, you should still have to pay a certain degree of cost. Perhaps I've misunderstood your question.
It wouldn't be on the basis of the evidence. It would be the conduct of the defendant. It may be that it would be prudent for you to consider that further and perhaps revert to the committee.
I'm happy to do so. May I just clarify what you mean by the conduct of the defendant, Mr.
Well, in terms of the way they have behaved all the way through the process, as it were. But
so, for example, that would be what they were unconvincing as a witness, or
I don't think it would be unconvincing as a witness. It would be, I mean, it's a discretion afforded to the judge. It's the principle. I think the committee would benefit from clarity on the point.
I'm actually just pondering, because I think in civil cases, so I'm long out of practice, is that the sheriff will look at conduct in the broadest sense of a pursuer or a defender in a case that may be prolonged and necessarily ran costs. There are ways round, or not ways round it, but there are things like minutes of tender, obviously, in civil cases that are an alarm about expenses. But the sheriff has very broad discretion in civil cases, certainly, to look at the way a case has been run and therefore consider about how the expenses might be allocated.
Indeed, Convener. I think that's right, but here we come to a fundamental distinction between civil and criminal justice, which you will understand, I'm sure, and I'm concerned that the motivation behind this bill, when it talks about bringing criminal cases into line with civil justice cases, is that it misses that fundamental distinction that it's the criminal law and it's the criminal process that can deprive you of your liberty. And the stakes are simply distinct and far, far higher. And I'm rather concerned by the language of consistency, uniformity, suggesting that there are anomalies between civil and criminal cases and that we should bring criminal cases into line with civil. That is not to discount the real problems that there are in civil legal aid and that the outcomes for people in civil legal aid cases
No, I
are
don't
enormous.
go into the detail of it. Yes, there was just a comparison I was making about the discretion of sheriffs and conduct of matters.
Indeed.
I've got Graham on a substantive separate one, then
Please.
John.
It goes to the final paragraph in your submission. Will the bill really save the money envisaged? It's brief in your response to that headline.
Yes.
Could you analyse that a bit further for us? I think that the sums involved in terms of the perceived savings were relatively small in the scheme of things.
Yeah.
Could you tell us what you think your forecast would be?
Yes. I mean, looking over the financial memorandum, I'm not sure how much or to what extent, if at all, it really takes account of, if you like, behaviour displacement or the adaptation of behaviour which we can expect as a result of this. It may well reduce SLAB's overall costs. It may well do that. It may well reduce their budget. But I'm sure that there will be knock-on consequences approaching the figure concerned, maybe more, maybe less, in terms of the overall system, the displacement in terms of the overall system. I mean, there are two obvious consequences which you've heard about before and I'm sure come to mind of members of the committee. One is that there's likely to be an increase in unrepresented cases. I know it has been said to you that in England there has been no apparent increase in the level of unrepresented cases. The problem with that is that there are so many variables in the system and that has only been in place for a couple of years that it's very, very hard to tell, and without a dedicated study of that, we really don't know. So there may well have been an impact, but it may well have been contradicted by other factors. So an increase in unrepresented cases is going to be a real headache for the courts. It's quite often said in the popular press that lawyers drag out cases now at the high end of the celebrity, and that may be true. But at the lower end, as I think you'll be well aware, Mr. Pearson and others, in fact, lawyers tend to deliver settlement. They're pretty good, compared with unrepresented clients, at getting the case done, persuading clients to plead guilty to something at some stage. They are very, very important. And in fact, one of the drivers behind the history and the increase in legal aid has been because, in a sense, it's efficient to have defence lawyers representing clients and delivering quicker, speedier outcomes. Unrepresented clients are bound to lead to delays. The second factor, I think, that is likely to come up is, of course, collection in terms of contributions. And you've heard from members of representatives of the Law Society, EBA, GBA, and so forth on that. And I think their concerns are reasonably well-founded. SLAB has said that a defence solicitor should take a commercial judgment as to whether or not a client is, if you like, a good financial bet overall, and in some instances take the hit of a client not paying up their contributions quickly. So that means that in certain cases, the solicitor should, according to that logic, that commercial logic, drop certain clients who are considered not to be good bets. For example, the client who's maybe not a regular customer, as it were, which may be quite a few of these cases. And there is a real danger that we will end up with unrepresented clients as a result of this, I think. They are two of the key worries. I think you could see in terms of contributions being paid, or we could just say fees, because that's after all what I think Section 20 suggests that they will be. They'll be essentially fees. Fees not being paid by the client, then you can see that there would be a commercial reason for a defence solicitor to say to the court, well, actually, I haven't had my contributions, or perhaps to present it in a different way and to try to adjourn the case, look for an adjournment while they're waiting for contributions. It's bound to slow the system down. SLAB are bound to be better at collecting contributions than defence solicitors, although, of course, no one's going to want to do it, and it's a dirty job. And so, you know, the idea, I think, is to farm it out to individual defence solicitors, and if they can't get the money out of their clients, too bad.
But before you move on, will the PDSO not step in? I mean, I think I raised that last time.
Yes, I think I saw that in the transcript. Well, one would hope in one sense that the PDSO steps in. I'm agnostic on the debate of the PDSO versus the private firm. Would they have capacity to do so? And as I understand it, the PDSO have got to collect contributions as well, I think, or maybe I may be wrong on that, whether SLAB's going to do that for them. I think
that's right. I think that's the...
So if they have to collect contributions themselves, then they're up against the same problem, although they might have better resources. I don't know if they'd be plugged in to information systems in a better way. If, on the other hand, it's decided that the PDSO doesn't have to collect contributions and SLAB does, well, one has to ask about the logic of that.
Thank you.
It seems to me to be much fairer if you're going to have a system of contribution, A, for SLAB to do it, even though, of course, they don't want to do it because it means more in terms of their headline budget. So doing this is merely displacing a cost onto someone else, and it's going to lead to if you like, adaptive behaviour, so that solicitors will look for adjournments, will drop clients, and that will slow things down. So it's going to displace costs away from SLAB's budget onto other budgets, the court service budget and so forth. It seems to me to be fairer to ask SLAB to collect it, and secondly, to collect those contributions once we know the outcome of the case, not beforehand. And that seems to me to be fundamentally unjust. And I simply can't fathom the justice of saying that someone who is acquitted is going to have to then pay the costs of the state prosecuting them, putting them through that whole process, and then saying, and you've got to pay for that. No, you won't get a refund. I would have thought, you know, that seems fairly astonishing thing to do.
Graham, you've another separate question.
Please, just to take up that last point you made there about the completion of the process, it may well be astonishing, but I think the practicalities of attempting to reclaim from someone who didn't get the outcome they sought might be quite a challenge.
Yes.
And one that I don't think anybody would be volunteering for, SLAB or otherwise. Yes. My final question to you, in the light of the evidence that you've given us in your written submission, and thank you for that, and what you've told us this morning, with 20 years of research into the criminal legal assistance in Scotland, do you have any advice for the committee about how we can therefore improve it? And obviously there is a concern about costs. Yes.
Could I just take the first part of your point first? And I think you hit the nail on the head when you intimate that the concern, of course, is about the practicality. If you leave it to the end of the case, the difficulties of then claiming that back from people. And that's true. We're talking about a relatively small sum of money, relatively speaking. And of course, that has to be weighed against the justice of the matter. Okay, so do I have advice for the committee? Well, difficult. It seems to me that...
I'd like to hear it.
I think there has to be a proper impact study, for one thing, in terms of how this is going to impact on people. I think the committee has heard from, Capability Scotland, for example, on how this might impact on disabled people. Will there be... there are potential questions about indirect discrimination as well, in that this may well impact on disabled people. It will probably hit women harder as well. Ironically, at a time when the justice system is trying to bring women out of the justice system, as it were, particularly out of the penal system, following the Commission on Women Offenders report. And I think there needs to be a proper pilot. The financial calculations need to really take account of not just the so-called savings to the legal aid budget, but the possible and likely, I would suggest, displacement factors. in terms of the overall court budget, and a proper study of what this will do in terms of the levels of representation and unrepresented clients. And, of course, a proper study in terms of what it may do in terms of the level of guilty pleas and people giving, if you like, insincere or guilty pleas. I don't actually think I am guilty, but I'm just pleading guilty to get the thing over with.
Thanks very much.
Yes, yes, it's on the piloting and so on.
Well, it's
Yes.
on the point that Dr. Tata just made. Can you unpack a bit, Dr. Tata, what you meant by it will have a more of an impact on women? Can you explain that?
Well, I mean, I am no expert on income distributions, but members of the committee will be well aware that women tend to have lower incomes, tend to often bear higher family costs. And I think you've had a submission from Families Outside which pointed out the collateral consequences of payments, fee payments, or contributions as they're being called, in terms of families. And I think one could see that having a detrimental impact potentially on women. I mean, that may be something that needs to be looked at properly, but you know, obviously accused people don't simply live in isolation from everyone else. They live as part of families. So what consequence will that have on, for example, you know, single mums with children? What consequences will that have on those people? Now, I know that I think this links up to another point or another question. Where will all this end? Once one accepts the principle that there should be fee payments, because this is what they are, called contributions, fee payments, even if you're then acquitted. Once you accept that principle, and we have it written in the £68 a week disposable income, you know, there is a danger that there is a slippery slope here. Will more and more people get drawn into this net? Once we accept that principle, then why not ask more people to contribute? You know, if the economic situation doesn't improve, we're told that this bill is motivated or in a sense incited by the economic downturn. If things don't improve in another 5 years' time, we'll be back again discussing that not only 18% of the population of cases will have to make payments, but 30%. Why not go higher? So there is a concern about slippery slope. I appreciate I haven't fully answered your question about women because I'm probably not best qualified to do so, but there is a question there, I think, to look at.
Can I just clarify, when you say pilot, I take it you mean operate, if this becomes law, across Scotland for a period of time to see if some of the issues you've raised and concerns about the fallout, unintended consequences actually happen, rather along the lines perhaps of a sunset clause, something like that, where, you know, it continues if everybody's content, but otherwise the legislation falls or whatever. Is that the kind of thing you're talking about? You couldn't pick an area. You'd have to do it Scotland-wide. Yes,
that's an interesting question, Convener. I mean, that would be one option, to have a sunset clause and to say, let's see how it goes, but you'd need to leave it for 2 to 3 years. I mean, in previous research, we've tended to find that solicitors don't end up adapting their behaviour for a couple of years. I mean, you take fixed payments, for example, you take the introduction of disclosure. It's taken a couple of years for defence solicitors to alter their practices, even though they're aware of the commercial imperatives. So you end up allowing it to happen for 3 years, something which which some of us think is fundamentally unjust. The alternative, as you say, is to look at doing it in one area. I don't have any, you know, definitive answer to give you.
You could do that. I don't see how one sheriffdom could possibly run that and everybody else is getting it, you know, not paying contributions in another. I mean, I could see all kinds of unintended consequences of that. So it seems to me we've got to be very careful about using the word pilot in these circumstances. We're very concerned about justice.
I absolutely agree.
And proper outcomes and proper test of how something operates in practice. So, I mean, I'm looking at what you're saying. The word pilot perhaps is not the word we want, but perhaps more Scotland-wide. And then, Graham, what have you to say? I'm not asking you to give evidence, but if your question is similar.
I mean, one of the points I would put to you is that I think the practice in Scotland is to try and collect together cases against a named accused from across the country, rather than have trials in separate locations nowadays.
Yes.
So how would that
Absolutely.
pilot operate you import
Thank
cases?
you.
I take your point, Mr. Pearson, and convener. You're right that it leads to all sorts of anomalies and injustices. Equally, this bill, as envisaged, leads to all sorts of anomalies and injustices. I mean, my view and suggestion to the committee is that asking people to pay, especially if they are acquitted, is fundamentally unjust.
We hear that, but just we're testing your proposals and remedies and possible remedies. I've got John to be followed by Jenny again. John?
Thank you, Convener. Morning, Dr. Tata. I'd like to ask you a question that arose in the written evidence and was followed up in oral evidence that we heard from Professor Alan Miller, the chair of the Scottish Human Rights Commission. I don't think it's certainly not directly alluded to in your evidence, and it relates to Section 21, the appeals process, and what was felt to be, and I've noted, I think it was Professor Miller correctly, a lack of clarity around that. The situation where an appellant dies, the appellant would have been eligible for aid, and the family would seek to clear his or her name, but they wouldn't be eligible for assistance. Do you have a view on that?
Well, again, I think this is fundamentally it's very problematic where the family might be asked to make contribution in the case of a deceased person. Is that what you're getting at?
The deceased would have been eligible for assistance to further their appeal, but the family wouldn't.
Okay,
or the authorised person, I think is the term used, authorised person.
Yes. I don't really have a view on that, Mr. Finney.
Okay, thank you.
Jenny?
I just wanted to briefly add that the point about a pilot was something that was also mooted by Dr. Alan Miller last week, so any joint proposals would be good to look at.
Okay, yes.
Have questions? Rod?
Just a small point in relation to the numbers of unrepresented accused. Would you accept that probably information in relation to that statistic could be kept fairly easily in a relatively short period of time? We would be able to establish whether there were problems with increasing numbers of unrepresented accused?
Yes. Potentially. The problem with simply looking at whether has there been an increase after, say, 2013 in the number of unrepresented accused is whether or not there are any other factors that might have influenced that. So what you need is also some kind of dedicated study which looks at accused persons' decision-making and why they chose to do what they did. And the potential danger with simply looking at whether there's been an increase in the numbers or not, which is what SLAB quotes as may have happened in England and Wales. The difficulty of that is whether it may mask other factors which may contribute to any changes or no change.
Yes, I have a final one, which I don't think we've touched on. I think the government has suggested allowing SLAB to collect contributions in summary criminal legal aid would create a perverse incentive for solicitors to encourage their clients to plead not guilty.
Yes, I think this is...
Do you agree?
You identify what I suspect is probably the driving motivation behind all of this. As things are at the moment, certainly solicitors have said, and solicitors that I've interviewed or studied in recent years have said, well, actually, it's an awful lot more hassle to try and get someone's payments from them. So the easier thing to do is a plea of not guilty. So that point is valid. However, there is an awful lot of discussion about so-called perverse incentives, and when SLAB and the Scottish Government in recent years tend to talk about perverse incentives, the only perverse incentive in terms of pleading that they have in mind is that more people should plead guilty. Now, they say that all they have in mind is earlier pleas of guilty. All of this has to be balanced against the reality, if you like, for accused persons, which we should be careful not to be complacent about. And if anyone has kind of been in the situation of being an accused person, including professional people, including in some situations solicitors, one quickly realizes that it's actually an extremely stressful and difficult
My police weren't being maligned as much as my former profession. But
Different of you, surely not a solicitor.
well, there are some famous cases of solicitors being victims of miscarriages of justice. And even they thought, surely this wouldn't happen to me. And I think this is one of the dangers, is that we are forgetting, or the arguments behind the bill forget that there are already very strong drivers towards guilty pleas at the moment. And there is also the real danger, and there is some research which suggests that people who plead guilty don't always A, believe they are guilty, and B, their solicitor necessarily believes that to be the case. So there is the danger, if you like, the other way. But the only thing that the documentation behind the bill has been talking about are perverse incentives. Let's get people who are pleading not guilty to plead guilty. But we need to balance that against the context of the fact that there are already huge drivers. Remand, emotional attrition, getting the whole thing over with, the simple fact that most people are not that able to resist the pressure from the entire system, if you like, in terms of maintaining a not guilty plea. So many accused people that I've interviewed, and indeed defence solicitors will say privately, that yes, absolutely, people plead guilty to things that they don't believe they are guilty of. So there are also already plenty of drivers in the system that encourage people to plead guilty when they may not, in fact, be guilty at all. And what the system needs to be doing is not to be trying to encourage more people who are pleading not guilty to plead guilty, but to get it right, so that people who are actually guilty are pleading guilty, and those that are not plead not guilty.
I'm going to thank you very much. I'm going to stop there, and thank you very much for your evidence. Thank you for your paper, which was very helpful. I'm going to suspend very briefly for 5 minutes while we change over witnesses. Thank you very much. We're now resuming, and I welcome the second panel of witnesses to the meeting. Kenny McCaskill, Cabinet Secretary for Justice, and Scottish Government officials, Colin Mackay, Deputy Director of Legal Services Division, Ondine Tennant, Policy Officer, and Nicholas Duffy and Felicity Cullen from the Legal Directorate. And Cabinet Secretary, I'd ask you if you like to make an opening statement.
Thank you, Convener. The bill is part of a series of measures being taken forward under the Making Justice Work programme. It takes forward two separate priorities: creating a Scottish Civil Justice Council and expanding the scheme of contributions and criminal legal assistance. The Civil Justice Council was an important recommendation of Lord Gill's landmark review of civil justice, and I'm pleased that there's been almost universal support for the creation of this body. For the first time, a body will have oversight of the entire civil justice system, including vital matters such as divorce and the care of children, housing, debt and personal injury. As Lord Gill made clear, our justice system has a proud history but must modernise its rules and procedures if it is to continue to serve Scotland well. The Council's first, very significant task will be to take forward many of Lord Gill's detailed proposals through court rules. Establishing the body now will allow it to prepare for the legislation which will reform the structures of the courts, which we'll be consulting on in the coming months. Once the Gill reforms are implemented, the Council will continue with a wider policy function to ensure the system continues to improve. We have listened carefully to the comments made about the composition of the Council. Overall, we think the bill strikes the right balance to allow the Council to take account of the range of interests in civil justice and have the technical expertise for its detailed work, without creating an unduly large and cumbersome body. There's also flexibility in the bill to allow the Council to evolve as its role develops. On the procedure for appointment to the Council, we believe that it is right for the Lord President to have the lead role in determining the make-up of the body. The Council is primarily there to advise the Lord President in discharging his responsibilities to ensure the effective administration of the justice system. And we agree that the appointments process must be transparent and robust. And I was pleased to see the Lord President confirm his commitment to those principles. Turning to Part 2, this sets out our proposals to introduce contributions in criminal legal aid. Again, I'm pleased to see that many people in the justice system, including the Law Society of Scotland, have accepted the principle that it is right that those who can afford to pay towards the costs of their defence should do so, as already happens in civil legal aid. That must be right when public finances are under such pressure. The expansion of contributions will allow us to target legal assistance to those who need it most, and it will correct the manifest injustice that a victim of domestic violence who goes to court to protect themselves may be liable for a contribution to their civil legal aid, while a perpetrator could receive criminal legal aid with no contribution. I recognise, though, that concerns have been expressed about the detail of some of the proposals, particularly that the income levels are set too low, that collecting contributions will create difficulties for law firms, and that it may affect the human rights of accused persons and interfere with the administration of justice. I'd like to allay each of these concerns. On the level of eligibility and contributions, it is important to remember that the starting figure of £68 a week is not gross income or even take-home income. It is the income a person has after deducting a long list of costs, including housing costs, council tax, childcare, loan repayments, maintenance payments, costs associated with disability, and an allowance for dependent spouses and children. On top of that, the board has a discretion to waive a contribution if undue hardship would be caused. The Scottish Legal Aid Board has provided the committee with a number of scenarios showing that the level of contributions for people earning several £100s a week will often be modest, and some people who would already pay a contribution under the ABWAR scheme will actually pay less in future. And I've listened particularly carefully to the concerns expressed by Capability Scotland about disability benefits. It is hard to give definitive reassurances on these benefits when the UK Government is in the middle of introducing major benefit reforms. But I am happy to give an undertaking that the Government and SLAB will discuss with Capability Scotland what further provisions can be made in the regulations to ensure that disabled people are not placed at a disadvantage. And I also appreciate that many criminal firms will feel that collecting their fees through summary contributions is a further burden being placed on them at a difficult time. But I do not think it is unreasonable. Most contributions will be for modest amounts, and the firm who has a relationship with the client will be far better placed to collect that money than the board. Slab modelling provided to this committee shows that the impact on a firm's business is unlikely to be large. Medium-sized firms might have to collect from between 29 and 167 applicants a year, and contributions would only amount to between 2.5% and 4.2% of the legal aid income, not total income. Frankly, if we did not proceed with contributions, the impact on firms of any alternative saving measures would be significantly worse. Following discussions with the Law Society, we took steps to reduce the impact on firms, for example, by ensuring solicitors can treat contributions collected as fees. The Law Society has also pointed out that there are problems with collecting contributions when providing assistance at police stations, and I'm happy to discuss further with the Law Society whether we can remove those difficulties. Finally, concerns have been expressed that people who fail to pay their contributions may lose their representation, causing problems for them in the courts. I don't believe that this is a serious risk. The vast majority of people will have no contribution. Most people who do have a contribution will only have a small one, and most of them will pay it. Currently, solicitors may choose not to collect contributions for advice and assistance in ABWAR, and as the board's modelling shows, just under half of those with a contribution under the new system will be asked to pay less than the current maximum of £142. There may be a small percentage of cases where a solicitor cannot get a contribution from the client and decides they must withdraw. I accept that we may need a safety net in some of these cases. For example, that the PDSO steps in if no other agent is able to act. As we've done throughout, we'll work closely with the board and the Law Society to ensure that practical arrangements can be put in place, and I'll be happy to report on the outcome of those discussions before stage 2. So I hope that this gives some helpful background and reassurance, but I'm of course happy to take the committee's questions.
Thank you very much, Cabinet Secretary. And can I remind committee that we're going to aid the OR, and therefore our stage 1 report. We'll start with part 1 of the bill. Questions on that, please. Then we'll move to part 2 of the bill. So part 1 of the bill, questions on that, please. Jenny.
Thank you. Good morning, Cabinet Secretary. I have 3 points I'd like to put to you. The first 2 are regarding the balance of lawyers and lay people on the council. Do you think that the right balance has been struck?
I think so. I think we have to get balance about having experts on, the legal profession with clear expertise, balanced with others with perhaps less, jaundice is not perhaps a word, but with a different perspective. We also have the flexibility to vary numbers, so I think that we've got the right balance. The numbers are slightly below what the current Rules Council has, but I think the balance is there. And if there are difficulties, then we can seek to address them in due course. But it does seem to me that we do have a fairly balanced approach.
I mean, the balance between legal lawyers and lay people falls far short of the 50-50 balance that was recommended by the Spencer Review in England and Wales when a similar Civil Justice Council was set up. Is there any kind of move from the government to perhaps look at more of a balance in line with the Spencer Review?
Well, I think, what they have south of the border is slightly different. It's an NDPB. It's different from this. Secondly, I think we do have the ability for the Lord President to put on additional matters, and it does seem to us that the balance at the present moment is reasonable, but we do have, as I say, within the Act, the powers to make changes in terms of numbers if that is felt appropriate. So I think the current balance should be tried out and see where we get to.
On that point, Cabinet Secretary, why is the council being set up in Scotland as not an NDPB? What's the reason for that?
Well, I think that's, if I can assist on that point, I think there are various, of course, technical questions about what is and isn't an NDPB, but I think we have to take it back to what the function of the council is, and I think in thinking about that, we also have to look at the changes that were brought into effect by the Judiciary and Courts Scotland Act 2008, and what the 2008 Act did for the first time really was put the Lord President at the head of the Scottish Judiciary and at the head of the Scottish Court Service as a non-ministerial department, and with the statutory responsibility for the effective and efficient running of the Scottish courts. That's actually was said by the previous Lord President to be one of the most constitutionally significant pieces of legislation of the Scottish Parliament. But what it does do, which is different from England and Wales, is places the courts under a separate constitutional status, and the Scottish Court Service under a separate constitutional status as a non-ministerial department, whereas down south it's an executive agency. And there are lots of good reasons why that's the case, but it basically does put the LP, the Lord President, at the top of the system with the responsibility to ensure the effective running of the system. What the Civil Justice Council is primarily there for is to help the Lord President do that job effectively and to ensure that he has a broad base of advice and expert support in doing that. So the logic is that it's a body that's part of the framework around the Lord President and the judicial responsibilities of the Lord President, and as such doesn't fall to be considered as an NDPB, just as the current rules councils are not NDPBs. So it relates to, as I say, the kind of constitutional architecture of the courts in Scotland.
That leads me on to the third point I wanted to make about the use of the public appointments procedure. Cabinet Secretary, would you consider the use of the public appointments procedure for this new body?
Well, I mean, we don't rule out anything, but I mean, I think at the present moment what we have is a system whereby matters have to be vetted. The Lord President appoints all but the ex officio members and ministers' appointees. He must publish a statement of appointment practice for non-judge members. The statement must include a requirement to consult, that's ministers, the faculty when appointing an advocate, the Law Society when appointing a solicitor. I also understand that he stated to yourselves that his intention that it will be in line with the principles set by the Office for the Commissioner for Public Appointments in Scotland. So I think that we've got sufficient safeguards there. We should see how this operates, and given the statement of the Lord President with the checks and balances there about who he requires to consult, I think we can rest assured that we have adequate protections.
If there's no...
Sorry, if I could just add a small supplementary point on that. I mean, the public appointments procedure is specifically designed for ministerial appointments. I mean, that's how it's been developed, and it's been developed over a number of years with that particular focus. And these aren't, of course, ministerial appointments. I think so the public appointments procedure would have to be adapted in order to fit what's a different appointment regime. But I'm sure there's a lot the Lord President would want to take from the public appointments procedure in doing so.
I mean, if the Cabinet Secretary, if there's no departure from the principles of public appointment, and you're saying the scrutiny and balance would be there, why not put it in the public appointments procedure just to be completely robust and transparent?
I think we have tried to establish in Scotland that the judiciary are separate from the legislature and separate from the executive. That's why we passed the Judiciary Act that Colin Mackay has referred to. That is why it is the ministers that are given special obligations. With that, the judiciary is viewed separately and tangentially, but equally you have an assurance from the Lord President, who is not a minister of the Crown, he is the Lord President, upon the manner in which he is going to operate. So I think you would be seeking to make the Lord President act or be perceived almost as a minister when we have a separate matter through the Judiciary Act.
Cabinet Secretary, can I ask you, there's a layperson who chairs the Scottish Legal Complaints Commission, the Scottish Legal Aid Board and the Judicial Appointment Boards for Scotland. Would you consider a layperson being deputy chair of this new body to provide the balance?
I think that's a matter I would prefer to leave to the board to decide. I mean, I think what has to be at the pinnacle is the Lord President, whether that should be a layperson, whether it should be one of the other people there. I think it's a matter for the Lord President and for the Council to decide. I think that would be best dealt with by them. I don't preclude doing it, but I can't for the life of me see why we shouldn't allow them to take some decisions and discussion and see who they should deal with it.
Colin, followed by Rod. Colin.
Thank Good morning.
Morning.
At least one witness that we had previously has mentioned about the powers of the Lord President and the ability of the Lord President to act completely independently and partially with the powers that you have. And their words, if memory serves me correctly, was there could be conflicts of interest. Now, we did have this discussion last week with the various witnesses. Now, nobody is casting aspersions on the ability of the Lord President to act out the function, but just really your view on, is there too much of a conflict within the powers of the Lord President?
I don't think so. I think at the end of the day, we have a system established through the Judiciary Act, and indeed, you know, previous to that, in which the Lord President is our most senior judge. What we did do in the Judiciary Act was tie it in more closely with the Scottish Court Service. I think it's appropriate that somebody has to be accountable and call the shots for the judiciary. That's the whole purpose of Lord Gill's reviews, to try and create a more tapered system, and I think that's to be supported, which is why we support Lord Gill's view. I think it's important that somebody should be here to account, which is why the Lord President came himself. Equally, in terms of the board and how it will operate, we're not talking, I think, to be brutally frank, about a bunch of patsies. We're talking about the Chief Executive of the Scottish Court Service. We're talking about the Chief Executive of the Scottish Legal Aid Board. We are talking about representatives from the Faculty of Advocates and from the Law Society of Scotland. In my experience, not as a Lord President, but as a Minister, there are no pushovers. So I think that any worries that people may have about checks and balances are dealt with by the makeup of the committee, where not only do we have those individuals with a great deal of legal expertise and knowledge, but we will have representatives who are lay people, but who doubtless will not be simply put in there on a whim and a fancy, but will be people who have given a great deal of contribution to public life and have a great deal of attributes and talent. So I think it's appropriate that the Lord President should be at the apex. Equally, I have every reason to believe that he will work in harmony with those on the council with him. And if it's ever felt that he's getting out of line, and I don't think that would happen with the Lord President, or indeed any we've experienced before, I think that there's sufficient weight and gravitas on there to perhaps provide that counterweight, which I think is what you're alluding to.
Some scars there from encounters, but we won't investigate that. No. Colin, you further? Rod, please.
Morning, Cabinet Secretary. We heard in the first evidence session in the summer from Professor Patterson and Professor Mullen quite considerable support for the use of subcommittees to the Rules Council, involving a lot more specialists, particularly in terms of the drafting. I think the committee was probably slightly remiss. We didn't actually address the use of subcommittees in any detail with the Lord President, as I recall. But that, it seems to me, particularly in the early years, a lot of focus will be on rules involving a lot of lawyers. I don't know whether, A, you can comment on the use of subcommittees, and B, whether over a period of time the number of lawyers involved might drop off as we concentrate rather more on policy matters.
I think that the two matters there, dealing with the second matter, the number of lawyers, I think that could change. Equally, I think we always work on the basis that there's changes come through from time to time to reflect social and societal matters, but I think it would be possible to see the number of lawyers reduced, but that's a matter that would be crossed further down the line. In the interim terms of subcommittees, I think that makes an awful lot of sense, because sometimes people from the faculty will not have a great deal of knowledge about Sheriff Court rules. Equally, people from the Sheriff Court might not have a great deal of knowledge about Court of Session rules. So there may be some benefit in, rather than having everybody around the table who has limited knowledge, leaving it to a subcommittee to go away and look at matters. So I think in this Council, as with many others, the use of subcommittees for quite technical matters would make a lot of sense, and I'd be happy, though, to leave it with them.
Good morning. There was a lot of discussion about the 6 Lord President members. And the briefing seemed to suggest that such membership would broaden out experience on the council. Could you explain the thinking behind the provision of 6 Lord President members and what was envisaged these members would reflect? In what way do they broaden the experience?
Yeah, I think just building on some of the comments that have been made previously about the broad makeup of the council, we have, as committee members have said, a number of legal members, and that partly reflects the nature of the legal profession. Realistically, you have to have judges from each tier of the judiciary, because you can't have a council without a sheriff on it or without a court session judge on it. You have to have the faculty on it. You have to have solicitors on it. You do also have to have consumer representative members on it. But actually, the number of organisations and people who have specialism in consumer representation is relatively few. And in fact, as the committee may know, consumer focus, which is one of the places you would draw on, is currently under significant threat as part of the UK government's streamlining public bodies. So we're not necessarily hugely flush with lay people who would have the right kind of expertise to be on the committee. But you'll have seen a lot of the evidence has said, for example, people in the insurance industry might have a contribution to make. People with the experience of ADR might have an alternative dispute resolution might have conflict to make. People with the experience of equalities issues might have a contribution to make. So these were all the kind of different things that were potential to add to the mix of the council. But the view was taken that rather than have a long list of every single kind of interest group you might particularly think about, and then actually risk token appointments of people who perhaps don't have any contribution to make but tick a particular box, that there should be a fairly large potential pool of additional members for the Lord President to appoint people who would have those kind of contributions to make because they represent a particular issue that might be particularly pertinent either generally or at a particular time. I mean, this might change over time because there may be a view at one time that the needs of women or of unrepresented litigants or of whatever kind of special interest needs representation on the council. So it gives the Lord President, the council, a deal of flexibility to add people on as needed.
And was it envisaged that the Lord President would take advice from council members about who he or she would consider as LP members? Or would that be a very individual decision that would be made by the Lord President?
Well, I think the appointment is by the Lord President, but I think the statement of appointment practice, I'm sure the Lord President would want to take advice if the council wanted to give advice about the kind of people who might be perhaps needed to fill out the representation of the council. I mean, I'm sure that's something the Lord President would want to take into account.
Thanks for that clarification. A separate issue, nothing much has been said about the funding of the council. Has any projections been made about how much it will cost? And I know there's reference to who will fund it, but is there any forecasts? Have you worked out the budget? Does the council replace any other expense that the government currently faces?
Well, I think my understanding in its steady state after civil courts reform, it will cost between $313,000 and $375,000 per annum. That's between $87,000 and $149,000 on top of the current council's cost, which is $226,000. The bulk of it is for staffing, which is estimated to be between $274,000 and $311,000. That's an additional increase in staff banding, but the council will be funded by the Scottish Court Service, and it will be through the intended increase in court fees to meet the relevant costs.
So it's good luck to recovering the court fees then?
That's it. Yeah.
Right.
Could I just
of course, yes, certainly, yes.
You'll have heard earlier evidence which suggests that court fees might be quite difficult to recover in some circumstances. Do you feel that the business case that surrounds the recovery of court fees and all it entails there will cover the costs of the council?
Well, the court fees we're talking about here on civil matters, not criminal legal aid contributions. Equally, in my experience in these matters, I think they are fairly simple to recover on the basis that you don't really get out the starting blocks or don't move on unless you pay. And accordingly, there is an incentive that if you want to keep your case alive, then fees have to be met. So we don't anticipate any difficulties in the cost of recovery of fees.
I'm grateful for the evidence. Yeah, it's just to record on the evidence. Thank you.
Fine. Now I'm going to move on to part 2, which is the criminal legal aid. I think we'll have more sort of strenuous questions than this. Perhaps not. Perhaps they're all gentle now. John, are you gentle?
I strive to be gentle, Convener.
Good.
Particularly with the Cabinet Secretary for Justice. Good morning.
He's blushing.
Absolutely,
yeah. I've 2 questions, Cabinet Secretary, that could be seen as fundamental rights. And, excuse me, you alluded to the Scottish Legal Aid Board's discretion. Do you feel that that discretion is robust enough to deal with what are the unknowns about the UK Government's welfare reforms? Because that's clearly a developing situation.
Can I just clarify, is this the undue hardship point you're making?
Yes.
Right.
Well, I think in terms of undue hardship, yes, there's a very wide discretion there, and that will be able to be a catch-all, not simply for benefit reforms, but for simple people caught in a poverty trap, whether in terms of having had some income that comes in for what, whether it's a capital matter or whatever. The question of benefit reforms is a moving feast. I've met with Lord Freud, not simply about legal aid, more about how we deal with those who are in custody, and we wish them to be released from custody and not reoffend, and how it would be preferable that they could access benefits sooner rather than later. Some of these things are dependent upon changes. I think there's sufficient flexibility in legal aid regulations that allow us to try and catch up. But until we know where Westminster reforms are going, it's very difficult for us to be able to write regulations if we don't know where the end point is. But on undue hardship, yes, I think there's sufficient flexibility for the board to be able to address matters that will not simply be benefit related, but could very well be capital related.
Thank you for that. And the second, on the potential loss of representation. You alluded to the Public Defender's Service. Can you confirm that regardless of location, there will be no one accused who won't go unrepresented issues?
Well, I think there's 2 matters here. First of all, we think that all the evidence from south of the border in particular shows that the amount of unrepresented accused, there was hardly any increase at all from what existed before when contributions were brought in. Matters were the same. We are happy to enter into discussion with the Law Society. I wouldn't like to impose it upon them, but a safety net, which I think members of the committee feel greatly about. I'm happy to look about how we could do that with the PDSO. I think we all know that the relationship between the PDSO and the Law Society can be rather fraught, so rather than give you a formal commitment, this is what we are doing, that they might not necessarily wish to accept in any particular shape or form, I'm happy to give you an undertaking that SLAB are happy to engage with the Law Society to offer the PDSO as a safety net in any court and see if that can be dealt with. It might be that the Law Society would prepare to deal with this in other ways, and that's why I caveat it with that. Very much.
Would we be looking at the PDSO collecting the contributions?
Yes, the same procedure applies to the PDSO as applies to private lawyers. I can give you that assurance.
Thank you. Graham?
You will not be unaware of you will be aware that there's a lot of consternation expressed by solicitors generally and the advocates about this proposal. And there's been a deal of focus on the savings that may or may not be achieved in connection with the proposal. Dr. Tata, who gave us evidence this morning, indicated in his evidence that he wondered about the knock-on effect of non-payment of some of these costs to trials, to delays and so forth. Has that all been thought through by those who have put together the proposals, and what's been their estimate of the way forward in that regard?
Well, these matters have been looked at. I think I would preface it by saying I think there's 2 aspects here. This is driven by the requirement to address the cost of legal aid, and if we are going to be able to target money where we need to make sure that there's access to justice for those who are victims of domestic violence, that we can tackle those who have suffered from asbestosis-related diseases, then we need to make some savings. There's also, as I say, been a historical anachronism, and I think it's been referred to across the chamber, that there was something manifestly wrong that the perpetrator of domestic violence could access legal aid with no contribution, but the victim of domestic violence required to make a contribution to obtain orders, whether interdict, exclusion order, residence, or whatever protective orders. So there's a point of principle that in a time of austerity, when we do have to make restrictions upon legal aid, then perhaps those who perpetrate should also be prepared to contribute as those who are the victims. Equally, we have looked at this because we are doing this as part of the Making Justice Work programme. We wish to reduce case churn. All the evidence from south of the border is that there was no significant increase when they brought in this, and this system applies south of the border in terms of unrepresented accused. There still are cases, as you'll know from experience, where people sack their lawyers, some high profile, some less high profile, where people choose to do their lawyers. So that's a matter that has to be considered. But all our evidence is that that would not be the case. And equally, I am happy to give you the undertaking that the Scottish Legal Aid Board will enter into discussions with the Law Society about the opportunity or prospects of the PDSO being prepared to pick up in various instances to ensure that an unrepresented accused is covered.
In circumstances where a person has failed to pay their element of fees in one case and becomes subject of prosecution in a subsequent set of circumstances unrelated, the failure to have paid fees in the first case, will that ensure that in the second case it won't be considered for legal aid?
No, that wouldn't be the case.
No, I don't think so. I think there might be ECHR difficulties about something like that.
So you take each case in its own
I think each
circumstance?
application would have to be looked at on its merits. And that's how the circumstances would have to be, as Colin points out. So
a person who regularly failed to pay their part of the fees would still come back into the system each time?
Well, I think what you would find is that I don't think that circumstance would arise. Either some arrangement would have been made through the solicitor, or equally, I think you would probably find some desire to take the money back from them by pursuing them, if from a solicitor's perspective, would occur. So we can give you an assurance that they would not automatically be precluded from legal aid. We would not be able to do that in terms of ECHR. Equally, I find the circumstances hard to imagine that somebody would be regularly doing this. They would either be, I think, in a custodial sentence or would be making some arrangement.
Can I pick you up, Cabinet Secretary, on your language there? You talked about those who perpetrate should have to pay, and then you refer to victims. Now, basic tenet of our criminal law is you're innocent till proven guilty. The burden of proof is on the Crown and it's beyond reasonable doubt. So, you know, one's working, it seems to me you're working the basis that if you're brought before the court, you're guilty. And that's why, but may I just develop that to say that, because that touches on to the point that if you're acquitted, either not guilty or not proven, you've been brought by the Crown, who brought case against you, who failed to establish it, but you've had all the costs that entail through that. Is that not unjust?
No, I think the circumstances are different. At the present moment, people countenance a position where a victim of domestic violence has to go through proceedings and then can still have to meet her legal aid contribution, even although interim orders have become permanent. People can face an order for freeing to take their children from them, and we've seen high-profile cases in Scotland, and they have ultimately not been successful, but they don't have the legal aid contribution because it's done on the basis of those who have the ability to pay should make some contribution, and I think that that should have some parity with criminal matters. I do accept that there are some slight differences and significant differences in terms of, in some instances, the possibility of a custodial sentence, but in many instances that will not be the case. So, as I say, I think there is the parity argument between those who are victims in many matters, those who face matters relating to their children, and indeed those, as I say, who are facing the challenge of a criminal charge. It is an absolute tenet of our legal system that you're innocent until proven guilty. But the system north and south of the border is different, and it seems to me that it's perfectly reasonable that to get legal aid, and if you're required to make a slight contribution, you should do so. If you're acquitted, then that has just simply been what is reflected in other areas of the civil law, whether in dealing with a freeing order or dealing with domestic violence.
I'm not going to go and dispute this further, but I don't really accept that, because in civil cases, awards of expenses can be made. And parties will have, some may have contributions, but if they get an award of expenses that will pay for the contributions, they can have an award of expenses. There will be no award of expenses in criminal proceedings. Someone could be in an extreme case where they're taken to a criminal trial and they're found not guilty, and it's found out that the alleged victim, in fact, concocted the whole story. And that person may have gone through hell and high water, their name's all over the papers, they've lost their job, we had this in previous evidence, we know these things happen, they are as innocent as the sky is blue, and yet they will have paid the Crown taking them up before the courts on behalf of the public interest. And there does seem to me to be an injustice in that, and it's not like for like. Either in the consequences to you, either through the processes of the system or in public in the newspapers, or is there anything similar in that there's no award of expenses, you've been taken against your wishes? Now, a defender in a civil case who's taken, who doesn't want to be there, who succeeds, may very well get an award of expenses against the pursuer.
Have costs in criminal matters. That's a circumstance that they have south of the border. And clearly there are circumstances in civil matters in which expenses can be awarded, but equally there are a variety of other type of events where that doesn't apply, whether it's an investigation by the Customs and Excise or HM Revenue and Customs. All of these matters which can be extremely difficult and dangerous, whether you're an individual paying his taxes or a member or a firm. What we're talking about here, and let's remember what we're dealing with here, 82% of people will not have any contribution at all. 82%. Of the balance who remain, 44%, almost half, will be paying less than £142. That seems to me a small amount. Others, will have a contribution to make, but as I say, it will not be a huge contribution. It will be related to their income. And it does seem to me that if we wish to be able to deal with other matters, and you've made points about the aspects of people being traumatised, but if you want to be able to offer legal aid to people in other fields apart from criminal law, then we've got to make some savings someplace. And it does seem to me that those who face a criminal charge should have to make a modest contribution where they can, exactly the same as those that find themselves in extremist circumstances with their children or with a violent partner equally have to do so.
Do you wish to follow this up, Graham?
Yes, please. Hopefully to encourage the Cabinet Secretary to recognise that in the circumstances of domestic abuse that you outlined there and the apparent inequality, in many cases the violent partner maintains and lives within that family unit post the charge, and therefore any contribution is likely to come out of the family budget rather than just, as you've indicated, a perpetrator's pocket. And the impact of that needs to be considered. The second point that I wanted to ask is that I don't see anything in the provisions here in legal aid which would deal with a matter of some concern to many members of the public, and that's those organised criminal types who live affluent lifestyles and yet still seem able to obtain very substantial legal aid and pay nothing for it.
Well, I think there's two aspects.
140 quid help there.
Yeah. Well, I think there's two aspects there. First of all is the aspect in domestic violence and the partner residing there. I think many of the changes being made by the Crown in terms of bail would address that, and I think those circumstances may arise, but in my experience they're becoming fewer and fewer as police and Crown quite understandably, and indeed the sheriffs, tighten up. On the other aspects, these people, I do not believe, should not be getting legal aid. I think we have all heard stories. It would be long to me to go into individual matters, as you can understand. But I think it would be fair to say that I think the Legal Aid Board, will investigate matters. I think this is also a matter of putting on record that legal aid in criminal matters should be subject to means testing. That is the case at the present moment, but I have to say, it's never, when I practiced, and I haven't practiced for 13 years now, it was never particularly a great deal of scrutiny, and I think this is a sign of making the changes to make sure that the people you refer to, who I think we would all agree are entitled to a presumption of innocence in terms of the criminal charges, but given the assets that we know they have, should not be getting legal aid by managing to subvert the system.
I mean, I'd just make the point again in the domestic violence situation. Many of these situations, the various people come back to live together in the family unit, and therefore these payments would come out of that family budget. I know that often it's difficult to understand why people continue to suffer in that environment, but the truth is that in families, often for children's sake and so forth, they do come back together. So the contribution will come out of the family unit rather than just out of an accused person's pocket. And I just make that point in the passing.
Well, I think there are a number of points in the scheme that could potentially address that. I mean, one is, insofar as the two people's resources are separable, I mean, if there is clearly a conflict of interest, if one of the people is the victim, then you wouldn't be assessing their income or resources as part of the contribution. So any savings that they had would not be part of the contribution. There are also allowances in the scheme for dependents, obviously, and again, if there is evidence that this would cause hardship to a victim or an alleged victim, then that's also something that the board could take into account to ameliorate that situation.
Thank you.
Spouse's income.
Thank you, Convener. On that specific point, what legal advice have you taken on the legality of considering a spouse's income when, say, a husband is accused but his wife's income is taken into account? Is that fair? Is it legal? Is it right?
Well, yes. I mean, that's what we do in civil matters. I mean, to some extent, these are a replication of matters that have long since existed, whether it's in divorce, protective orders, accident claims, or whatever. So these matters have been around for quite some time.
Can I just return to, before we go back onto that, can I turn back to an unsuccessful prosecution? Let's take it to the extreme where the sheriff, the trial collapses and the sheriff says, this should never have been brought before me. You know, the Crown has made such a mess of it, this should never have been brought before me. Is there not room there in those very narrow circumstances for a sheriff to have discretion if the accused has been paying contributions and it's been such a mess by the Crown that they're entitled not to be out of pocket?
I mean, I'm happy to look at that. I think in discussions with the Scottish Legal Aid Board, I think people would be aghast if, for example, a case was subverted because a witness was intimidated or something happened there and something that clearly had caused great cause for concern. But if the committee is so minded, I would be happy to discuss with the Scottish Legal Aid Board whether there was any opportunity to seek matters. I think that would be complex, it would be fair to say, but, you know, we have seen matters that were given to the discretion of the sheriff, and given that legal aid was previously at the discretion of the sheriff for solemn matters, until that was changed some years ago. As I say, it's not without its difficulties because we don't have the same concept of south of the border of people being fined or then having expenses awarded against them. This is meant to be the justice system, and exactly the same as people pay taxes into it, people make a modest, and I would emphasise a modest contribution. There might be an argument that seeking to claim back £85 or whatever is more hassle than it's worth, but if you do feel it's such a point of principle, but it comes back to 82% will have no contribution at all. Almost half of those who have a contribution will have a contribution of below £142. I think that's a small amount to be able to contribute to make sure that we have, as I say, a legal aid system that can meet the challenges we face and that can provide for all, not just those who face criminal charges, but those who face other matters, whether it's a child with medical negligence circumstances, all of which are hugely expensive and need supported.
I think we accept the difficulties for you on the budget, but I think the point we're pursuing is injustices that may happen that, notwithstanding pressures on budgets, would not be appropriate given Scots law, in fairness to the alleged accused in certain circumstances. Jenny.
Cabinet Secretary, sorry, I'm just a bit uncomfortable with your answer to me about the spouses, because you said that spouses' income are considered under civil law, but when you enter into a civil dispute, it's by choice. You enter into that, and presumably that's discussed in the home with the spouse, and that's decided to spend that money on the case. A criminal case, you find yourself prosecuted not by your own choice. And therefore, do you still think do you think it might actually come into conflict with ECHR law that a spouse's income is considered as part payment for that prosecution?
No, don't. I don't think you're right in your concept of civil proceedings. I don't think people choose to have their children taken off them. They can volunteer that. But in the main, it's usually social work and council lawyers that would choose to apply for a freeing order. I don't think people choose to be beaten black and blue by a violent partner. They may sometimes, sadly, not get out, but they don't choose that, and they have to take protective orders. People don't choose to suffer an industrial accident affects them, and they're required to take action. So I would dispute your suggestion that we almost have some litigation of choice. Sometimes you are left with no alternative but to pursue a civil remedy. It's not a matter you chose to do. It's a matter that you have to respond to, or you lose your children, you're left incapacitated with no recompense, or you suffer violence and abuse, and none of these things are acceptable.
Moving on, Rod.
We heard from some practitioners, I think, with concerns that, I think, presumably particularly in relation to summary cases, that the periods of contribution would be so long that the case would have finished before all the contributions could be collected, and that could create additional difficulties. Have you any additional thoughts about the period of contributions, of ways in which it could coincide more closely with the likely length of the case?
I mean, we're happy to look at that. I have to say I don't really envisage that. As I say, when we look at the statistics of 82%, 44% less than £142, I think the likelihood is that the sum there would be collected relatively speedily. Equally, other arrangements can be made. So I don't anticipate a huge churn at all, but I don't know if, Colin, you want to comment?
Well, I think clearly where people are paying the higher level of contribution, I guess the supposition is that they have a reasonable level of income, and that might suggest a steady job. They've probably got a bank account. They're probably not the kind of person in the chaotic lifestyle that sometimes comes before a criminal defence solicitor. So I think even although the case may have been concluded and the person may not feel any kind of pressing need to keep paying the contribution, I think the chances of recovery of a higher level of contribution are greater than if it's the sort of 20 or 30 quid for somebody who basically doesn't have very much money. So clearly it's will be an issue in some cases, but we don't envisage it causing massive problems around non-collection.
On a separate subject of...
To clarify, because a bit confusion up here about, the joint income of the parties. If, let's say, wife is pursuing an action against husband or partner for an interdict and an exclusion order and all the stuff that goes with it, in those circumstances, are there incomes, and the others, the defenders, one's pursuing the other's defender, are there joint incomes considered for legal aid, or are they looked at separately because one's on one side and one's on the other?
Separate individual.
I just wanted it clarified. Yeah, I think that was what we need clarified for the record, not that, because in the circumstances you were describing, obviously one's the pursuer, the other's the defender, so there's separate incomes.
If you've
and
got
capital. Yes.
opposition there, then these matters have always been excluded.
And would be in criminal cases as well.
That for the record. Rod, sorry.
Carry on with a separate point.
Sorry.
I think I should refer to my declaration of interest as a member of the Faculty of Advocates. Last week, I asked James Wolfe QC from the faculty whether he had any information on what the likely level of reimbursement of expenses of acquitted defendants would be, particularly at the present time in privately funded. I think I should ask you, as a representative of the Scottish Government, whether you have any information on what the likely impact would be if we were to reimburse expenses to acquitted defendants.
I don't know if we have that information, but it has never been the situation, and indeed the point that was being referred to by the convener earlier, it would not be the case for somebody who is paying privately. They would not get their money back if they were acquitted, or as the convener pointed out, they were pristine, clean, and the case should never have been brought or whatever. That is simply a matter that would fall to them.
I don't think we have any very definitive statistics because obviously in privately funded cases it's not really a matter of public record what the costs of the case are, and even I think matching up the court statistics with legal aid statistics in terms of who's acquitted and who's privately funded would be difficult. I mean, certainly if it would assist the committee, we could see if we can, what information we can glean and what modelling we could give you on the costs of privately funded cases, but I imagine it would be fairly partial. We could also try and find comparisons with the English costs as well.
Finally, my final question is in relation to the proposals generally for contributions and the impact on access to justice. If, 2-3 years down the line, we found that this is creating a great deal of difficulty and injustice, what steps will the Scottish Government take to try and improve access to justice?
Well, I mean, most of these matters, this has to have primary legislation, but most matters thereafter, as in most current matters in legal aid, are dealt with by regulation. We have the ability to review matters. We will review matters, and where there requires to be tweaks or amendments, we can do so, whether that relates to civil matters, criminal matters, ABWAR, solemn, summary, or whatever.
Certainly pursuing the issue of, if one were to pursue the issue of Shrivel discretion, to make an award if a case should never been brought, and I say somebody was clean as a whistle, I would be anticipating that would be true of all parties, whether or not they were privately funded or get criminally laid. But on a separate point, we've had put before us there should be a pilot, or we think we've really looked at it being Scotland-wide, more of a sunset clause. What would your view of that be, a kind of suck it and see of this, so that all the stories of unintended consequences, distortion of processes in the criminal court, delaying cases?
Well, I mean, I don't think a pilot is feasible. We'd be better dealing with matters by way of regulations, and I give you the undertaking that these will be kept under review as matters are. Legally tends to be dealt with by regulations because, as you know yourself, and as the committee will have seen, we have to update them, whether it's in terms of the amount we pay or eligibility criteria, so we can deal with matters by regulation. I think a pilot in terms of a jurisdiction or across all Scotland would simply be, frankly, a guddle, and we would be better just getting on and dealing with matters. Going back to the comment that you were making about recompense or Shrivel discretion, I mean, these matters are fraught at the present moment. If somebody, because if you're suggesting that it goes across the board, whether legal aid or not, so if somebody can afford to bring in a high-powered lawyer to find some technicality, if you want to argue that they should be able to get recompense for that high-powered lawyer who's come in and found something wrong with whether it's a tachograph, a speed camera detector or whatever, then these are matters I'm happy to look at. I do think that things have always been fairly clear in Scotland that people do not pay contributions or expenses in terms of being imposed by the court. but we do have to make some contribution to meet the costs of legal aid.
I wasn't talking about failure to prove the case evidentially. I'm talking about the extreme end where a case should probably not have been brought in the first case. You know, a good defence counsel, yes, that's fine. I wasn't talking about those circumstances. I'm talking about where the Crown had probably made a mess of it and should never have brought it in the first place. Very unusual, but they do happen. And sheriffs do say these things occasionally. And that's very specific ones where I was looking for shrieval discretion. And I'm sure that if sheriffs were to start, if it did happen, or to exercise it in the wrong circumstances, there'd soon be appeals from the Crown. But I'd leave that sticking where it is.
We will reflect upon that.
The only thing that concerns me about this is you're talking about being able to change things by regulation. Of course, this is primary legislation. So if we find contributions for criminal legal aid per se are not operating as they should, we'd need to do something to this bill and you know, either amend it. We can't get rid of it because it's two parts of a bill, and that would be a wrecking amendment. Not that I'm suggesting that, but just putting that there. But if one wanted to sort of ensure that there was either a review clause in it, I'm not saying this is particularly the way Enbridge thinking about a review clause or a sunset clause. Pilots, I think you're quite right, would McGuddle. Would that be something you wouldn't even consider?
Well, I think what we're happy to do is to give you an undertaking to review, because the last thing we want to do is to tweak one aspect of the legal system resulting in difficulties in another aspect. That's why it's part of the making justice work position. It is, as you correctly say, primary legislation, but as I said at the outset, this is not simply that we have to make savings in legal aid, because if we are to provide for the areas that we all want to, we have to make sure that we balance the books. There is a point of principle here, which is that I believe that those who face criminal proceedings should also, as I say, have to make some contribution, if they can afford to, as those who face challenges in civil proceedings. So I'm happy to give you a guarantee and an absolute assurance that we will continue to review the regulations, that if there are difficulties, we will seek to amend them. That is how we deal with legal aid, and you will have, and I have been before you in a variety of legal aid SSIs in the past, and many just go through on the nod because they're upgrades or whatever. That seems to me to be the way to go, rather than a pilot that I think is really not feasible, or indeed a sunset clause that I think is unnecessary.
I mean, just
Sorry, I beg your pardon.
Sorry, Jim, just to give some clarity for the committee about what can and can't be changed. I mean, as the Chair has suggested, the principle of contributions is what the legislation is about, but the level at which contributions would be levied, although the bill specifies £68 a week as the starting level, that can be amended by regulation. I
understand that.
The issue about who collects it can be amended by regulation, so
yes,
it could be very
we understand that. That's process. I think it's the principle yes, that one would be looking at, whether there was unintended consequences of that. I perfectly understand the tweaking that can be done through regulations. Graham.
Thanks, Convener. I'm grateful to the Cabinet Secretary for committing to a review. Could he offer us some comfort by putting a date on such a review, given that the legislation may pass this year? Would he say that
I'm happy
a
to
date
work
in
with
3
you.
years' time? Or?
I mean, if the committee has any specific preference, I meet with the Chair and Chief of the Legal Aid Board on a very, very regular basis. I'm happy to take the views of the committee on whether you want it. Presumably 1 year might be too soon, but 3 years might be an appropriate period, and we could undertake to return to see how it's working out.
I think this is an issue we could raise at stage one debate and have it on the record, not just for committee, but for Parliament at large. I think that's lovely. Thank you very much. We now move on to the next item, and I'll just let some officials. Are you all staying? You're not. Oh, you've had enough of us, Mr. Mackay. No, you're staying. No, you're going. It's Mr. Mackay's going. Who do we have now?
No.
Colin Mackay is staying, and Felicity Cullen's staying. That's what it tells me. I'll just move on because it saves us having time to suspend, and they tend to disappear if I suspend. They run away and I have to catch them with nets. Now, Cabinet Secretary, item 3, Defamation Bill, UK Parliament legislation. And we're going to consider this, and can I thank yourself and Colin McCann, Felicity Cullen, for remaining with us to give evidence on this LCM. And Cabinet Secretary, again, can I ask you to make a short opening statement with regard to this, please?
Thank you. I'd like to thank the committee for the opportunity to discuss the draft legislative consent motion which it has before it in relation to the UK Defamation Bill. This bill was introduced in the House of Commons on 10th May 2012 to reform aspects of the law of defamation in England and Wales. It followed a consultation again in England and Wales only. The main reforms are designed to address widespread concern about defamation law in England and Wales. The reforms involve amending GB-wide legislation, the Defamation Acts of 1952 and 1996 for England and Wales only. The law of defamation in Scotland falls within the competence of the Scottish Parliament. It's not attracted the same criticism as the law south of the border, and the Scottish Government has no plans for wholesale reform in this area. Having said that, the UK Bill's reforms include provisions for qualified privilege for a limited range of academic activity, one of which was only included in the bill at introduction, following a recommendation by the UK Government Parliamentary Joint Committee in their report on the draft bill. The bill seeks to extend the defence of qualified privilege in relation to a defamation action to fair and accurate reports of what is said at a scientific or academic conference, and to create a new defence of qualified privilege for peer-reviewed articles in scientific or academic journals. As much academic research is done collaboratively across the border and conferences held throughout the UK with delegates attending from across the UK, the Scottish Government takes the view that it's desirable to have these provisions on qualified privilege extended to Scotland. Parity of protection in this sphere will facilitate robust and constructive scientific and academic exchange. The extension of these provisions to Scotland are the subject of the legislative consent motion before the committee. While the Scottish Parliament would be able to legislate for these devolved matters, there is no suitable opportunity to do so in the near future. The Minister for Community Safety and Legal Affairs, Rosanna Cunningham, wrote to Lord McNally, the UK Minister responsible for the bill, and he's agreed in principle to the provisions being extended. I therefore ask the committee to support the draft legislative consent motion laid before it. And I'm happy to answer any questions.
Secretary, yes. Graham.
Thank you. First of all, I would acknowledge that David McLetchie was the member of the committee who largely sought that we should examine this matter further. And I know that he would have been present but for other very pressing matters. Reports in the press recently seem to question some of the points that you've made in your presentation there, Minister. In particular, it indicates that your justification for Scots law being sufficiently robust was challenged by Alistair Bonington, who indicated that having practiced law in Scotland for 30 years and attended many conferences over the world where expert media lawyers discussed problems experienced when domestic law curtailed free speech, Scots law of defamation was one of the worst offenders found anywhere. And he indicated that it was time for reform. His view seems to have some sympathy with Professor Elspeth Reid at Edinburgh Law School, who indicates in her submission, her article which she published recently, that although matters weren't as urgent in Scotland as might be the case in England, the time has come for a fundamental review of the interests that defamation should seek to protect. I suppose in terms of, standard grade discuss, what's your view, Minister?
Well, I think Alistair Bonington challenged a lot of aspects about Scots law, not all of which I would share his opinion with. I have to say, I think on this, the law of defamation in Scotland has been relatively robust. We don't have the same issues that are arising south of the border with libel tourism and a whole array of other matters. That said, we should never rest on our laurels. I think the primary people to pursue this would be the Scottish Law Commission. I obviously meet them on a regular basis. They have not raised it as one of the matters that they are currently wishing to consider. It may be something that they'll come to in due course, and I would have thought that if there is a desire for some consideration of this, then it might be the appropriate thing would be to enter into discussion with the Scottish Law Commission to see whether they think it's urgent or something that should be done in due course or something that they be prepared to consider, because they will ultimately be the ones that will be responsible. So my suggestion would be to engage with the Scottish Law Commission to see if they share the same concerns as Professor Reid and Alistair Bonington, and perhaps see if, although it's not on their current work programme, whether it might be factored in by Lady Clark as something that they will have for future years.
When you say engage in discussion with that group, are you suggesting the committee should or the minister?
Either of us could I can either go back saying you've raised it with me, or you could write as the committee saying this has been raised, and do they have a view? I'm in your hands as to what you would prefer. It might be better to go from the committee rather than, hear directly from yourselves as second hand from me. I mean, what I can say is I've always found the Law Commission perfectly happy to engage. They're not part of government as such, and indeed I remember when I was in opposition meeting with them just to be appraised. So I think you'll find that they'll be happy to engage with you, and indeed there might be some merit in this, not just on the question of defamation, but simply on what other plans they are considering.
Okay, I'm grateful for that.
See, I've got a new phrase today: libel tourism. It's got a certain, well, it's contemporary actually, isn't it, just now? Well, it's very much so. I've got Jenny, then I've got Rod.
Cabinet Secretary, why do we need consistency for scientific and academic material but not for other published materials?
Well, I don't think there's a problem in that area. I think the reason that we need scientific and academic is that this is being brought in this bill. We could do primary legislation here, but we can access it. I think given that much of the stuff that's being dealt with in scientific and academic journals is pan-UK, it seems to me that, first of all, we recognise as a government this is a sensible thing to do, that there is a gap and an issue that needs to be addressed. The other aspects of the bill relate to the English law of defamation, which is not the same as the Scottish law of defamation, and where we think matters are fine. So this is about responding to the needs of those in the academic and scientific community so that there can be peer review, there can be free and frank exchange at academic and scientific conferences, but we can also provide some protection that people will not be unjustly defamed or libelled.
Just for clarity, Cabinet Secretary, Professor Bonington and Alistair Bonington and Professor Reid notwithstanding, has the Scottish Government received any representations from the Law Society or the faculty for to give consideration to reviews? No,
the major discussions that have been ongoing have obviously related to defamation of the deceased, which related to a public petitions committee in which my ministerial colleagues have been engaging. Matters have been looked at, but to some extent they're being held in abeyance pending the outcome of the Leveson inquiry, given that the defamation of the deceased in many instances related to newspapers. I think the decision has been taken that we will wait and see the outcome of Leveson before we decide to go thereafter. But I have to say, beyond that, it's not been a matter that's been raised with me by the faculty or by the Law Society. I did read Professor Reid's aspects, and I thought there were some points that I had some sympathy with. I wouldn't necessarily put myself in the same bracket there with regard to Alistair Bonington. But there we go.
I'd share that. Any further questions? I have to say, and I declare an interest here, I've got a son who engages in scientific and academic exchanges and research, and it's a dog-eat-dog world there, and quite tough. I think far tougher than being a politician, I have decided. Anyway, there we are. That concludes this evidence session, and thank you very much, Cabinet Secretary.
Thank you very much.
I now move into private... No, I don't. I move on to item 4, which is 2 negative instruments for consideration of Charities Restricted Fund Reorganisation. Scotland Regulations, SSI 2012-219, and the Charities Reorganisation Scotland Amendment Regulations, SSI 2012-220. The Subordinate Legislation Committee has not drawn the Parliament's attention to either instrument. Do members have any comments? No. You're content to make no recommendations? Yes. Now move into private session.